If you're a civil balance of plant contractor in Queensland and you've just received a defect notice long after your defect liability period has expired, stop. Before you mobilise a crew or admit anything, there are 4 things you need to understand. First, the DLP is not a complete shield. The expiration of a 12 or 24-month defect liability period under your EPC subcontract does not extinguish your exposure. You remain liable for latent civil works defects for up to 6 years under the Limitation of Actions Act 1974, QLD. The DLP expiring is not the end of the story. It's just the beginning of a different conversation. Second, regulatory intervention is strictly time-barred. The QBCC's power to issue a direction to rectify defective work is capped at 6 years and 6 months from completion of the work, under Section 72A(4) of the QBCC Act. That cap limits your indefinite exposure to regulatory enforcement. It is not absolute. The QBCC may apply to QCAT to extend it in exceptional circumstances, but such extensions are rarely granted, and the primary position strongly favours the contractor where the work was completed more than 6.5 years ago. Third, denial of site access is a practical and contractual defence. If an EPC head contractor issues a defect notice but restricts your ability to investigate the solar or wind farm site, that may support a defence against QBCC non-compliance on the basis that compliance was rendered impossible by circumstances outside your control. Document any refusal of access in writing immediately. Fourth, ground conditions versus defective workmanship. Proactive contractors often pivot civil foundation or access road defect claims by formally reclassifying the failure as a latent geotechnical condition, relying on contemporaneous interface sign-offs. This is not a simple assertion. It requires documentary discipline, but where the evidence supports it, it can fundamentally reframe the dispute in your favour. These are complex areas of Queensland construction law, and the right strategy depends entirely on your specific facts and your subcontract's exact terms. If you've received a post-DLP defect notice, seek independent legal advice before responding.